Hello students, your topic for today is Chapter 7 of Rajasthan Rent Control Act 2001. So this chapter is the miscellaneous one. It is covering the miscellaneous sections. Section 25, that is talking about the inspection of premises. So the landlord has the right to inspect the premises that are let out by him at the daytime after giving prior intimation of at least 7 days to the tenant. However, such inspection shall not be carried out by the landlord more than once in 3 months. Section 26 is the member and the staff of the tribunals to be public servants and their controller. So the presiding officers and the employees of rent tribunals and appellate rent tribunals shall be deemed to be the public servants within the meaning of Section 21. After Indian Penal Code, the presiding officers of rent tribunals and appellate rent tribunals shall function under the administrative and disciplinary control of the High Court. The presiding officers of the appellate rent tribunal shall exercise general powers of superintendence and control over the rent tribunal under his jurisdiction, including the power of appraising the work and recording the annual confidential reports of the presiding officers of the rent tribunals. The ministerial employees of the rent tribunal and the appellate rent tribunal shall be governed by the Rajasthan Subordinate Courts Ministerial Establishment Rules 1986, and for the purpose of these rules, the appellate rent tribunals shall be deemed to be the courts of district and session judges, and rent tribunals shall be deemed to be the court of civil judges. The class 4 of the employees of the rent tribunals and the appellate rent tribunals shall be governed by the Rajasthan Class 4 Services Rules 1999. So section 26A, that is the rent authority to the public servant and protection of actions. So the presiding officer of the rent authority appointed under this act shall be deemed to be the public servant within the meaning of section 21 of the IPC 1860. Then no suit or other legal proceeding shall lie against the rent authority in respect of anything which is good faith done or intended to be done in pursuance. Section 27 is talking about the limitation. So then section 28 is talking about the court fees. Section 29 is the act to have overriding effect. So the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or in any instrument having effect by virtue of any law other than this act. Section 30 is that the power to remove difficulties. So if any difficulty arises in giving effect to the provisions of this act, the state government may, by order published in the official gazette, make such provisions not inconsistent with the provisions of this act as appear to it to be necessary or expedient for removing the difficulty. Proviso for this is that no such order shall be made after the expiry of the period of 3 years from the date of commencement of this act. Then every order that is made under this section shall, as soon as may be after it is made, be laid before the state legislature while it is in session. Section 31 is the power to make rules. So the state government may make rules for carrying out the purposes of this act, and all the rules that are made under this act will be laid as soon as maybe after they are so made before the house of the state legislature while it is in session for a period of not less than 14 days, which may be comprised in one session or in two successive sessions, and it before the expiry of the session in which they are so laid, or of the session immediately following the house of the state legislature. Making any modification in any such of the rules or resolves that any such rules should not be made, such rules shall thereafter have effect only in such modified form or be or no effect as the case may be. So however, that any such modification of annulment shall be without prejudice to the validity of anything previously done thereunder. That's all. Thank you.